So welcome everyone. So today we will be beginning with the very important and interesting topic, that is the section 26 of Bharatiya Sakshya Adhiniyam, which was earlier section 32 of the Indian Evidence Act, which dealt with dying declaration. So it is a very interesting situation. So for example, any person who is dying, so before his death, he makes allegation on a particular person that whether this or that person has caused his death. So whether on the basis of that statement we can convict that person on whom allegations are made by the deceased person. So in relation to that, we have plethora of judgments, and along with that interpretations given by the various Supreme Court decisions, so that we will be discussing in detail. So we will be beginning with the section 26, which deals with the hearsay evidence. So what does hearsay evidence means? As a general rule, under Bharatiya Sakshya Adhiniyam, hearsay evidences are excluded. As per the section 55, which lays down the primary rule of Bharatiya Sakshya Adhiniyam, which states that all the evidences must be direct. Direct evidence means the person testifying before the court must have seen that fact or heard that fact, or he has perceived that fact by his any senses. But what does hearsay evidence means? Hearsay evidence means any fact or any testimony that you have heard from any other person. The perceiving of sense of any other person, ਕੋਈ ਤੀਜੇ ਪਰਸਨ ਦਾ ਬਿਆਨ ਜਾਂ ਕਥਨ ਜੋ ਕਿ ਤੁਸੀਂ ਆ ਕੇ ਕੋਰਟ ਦੇ ਵਿੱਚ ਟੈਸਟੀਫਾਈ ਕਰ ਰਹੇ ਹੋ. So that is the hearsay evidence. So there are some exceptions in Bharatiya Sakshya Adhiniyam, and one exception we have already studied under section 4, which was earlier section 6 of Indian Evidence Act, that dealt with the res gestae, where the statements or even act of bystanders are third persons who are not party to the criminal trial or who are not party to the suit. So the act or statements of even third persons are becoming relevant under section 4. So act or statement of third person will be a hearsay evidence. So that is one of the exceptions that we have already studied under section 4. Now we will be studying the second exception in form of dying declaration. The reason for making dying declaration as a relevant fact, which is even though a hearsay evidence, the reason is that any person who has become incapable of giving evidence, or any person who has died, or any person whose attendance cannot be procured by reasonable expenses, or it will cause very large delay. So for the purpose of that, the legislature has included some of the exceptions to the general rule in form of hearsay evidences. So to protect the evidences of those persons who are not available, so we have included hearsay evidences. So the purpose of section 26 is that any statement which can be written, which can be verbal, but the condition is that that statement must be relevant, which has been made by a person who is dead, who cannot be found, or who has become incapable of giving evidence, or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to be quote unreasonable, are themselves relevant facts in the following cases, namely. So section 26 provides 8 types of circumstances ਜਿੱਥੇ ਕਿ ਜਿਹੜਾ ਵਿਅਕਤੀ ਮਰ ਚੁੱਕਿਆ ਵਾ ਜਾਂ ਮਿਲ ਨਹੀਂ ਸਕਦਾ ਜਾਂ ਜਿਹਦੀ ਪ੍ਰੈਜ਼ੈਂਸ ਬਹੁਤ ਹੀ ਐਕਸਪੈਂਸਿਵ ਹੋਊਗੀ ਔਰ ਇਟ ਵਿਲ ਕਾਜ਼ very unreasonable delay, then under 8 circumstances any statement given by that person will be a relevant fact. Reason we have already given, as I have already explained to you the reason why this hearsay evidences are included. The only reason is that to protect the evidences, to protect the relevant facts of those persons whose presence cannot be procured, even because of natural reason or because of any other reason. Natural reason is that the person has died, or other reasons can be unreasonable delay or very high expenses. So we have covered the base of section 26. The base of section 26 is that it includes the hearsay evidences of those persons that we have already discussed. Now we will be beginning with those 8 circumstances. So the first circumstance, that is the most important, that will be most likely to come in your exams, that is the dying declaration. It states that when the statement is made by a person as to the cause of his death or as to any circumstances of the transaction which resulted in his death, in cases which the cause of that person's death comes into question, such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceedings in which the cause of his death comes into question. So there are 2 things. One, the cause of your death. Second, those circumstances that led to transaction of your death. ठीक है जी? And most importantly, ਜਿਹੜੇ ਬੰਦੇ ਨੇ ਕਥਨ ਕੀਤਾ or person who has made the statement, it is not necessary that the person is expecting his death or not. ਬੰਦੇ ਨੂੰ ਚਾਹੇ ਰੀਜ਼ਨੇਬਲ ਐਪਰੀਹੈਂਸ਼ਨ ਹੋਵੇ ਆਪਣੀ ਡੈਥ ਦੀ ਜਾਂ ਨਾ ਹੋਵੇ, that doesn't matter. So first one, the only conditions required under first condition is that the person's cause of death is stated, or the person's those circumstances are stated which led to transaction of his death. First is as simple as that. I will explain you with the examples. First is very general and simple thing. Suppose A hit B with the sharp knife. So B is under injuries and he's on a ventilator. So he's receiving the treatment at a hospital. So during his treatment, he stated to the doctor that A has stabbed him with knife, so that's why I'm here. So that after that statement, B dies. So B dies after giving the statement. So this is the simple and general thing. So that is stating the cause of his death. So that will be relevant under section 26 clause A. So now let me give you example of the second case, the circumstances which led to transaction of his death. So for example, so for example, there are 2 persons, A and B. So B is at his house. So A calls him outside. A ਬਾਹਰ ਖੜਾ, B ਘਰ ਦੇ ਅੰਦਰ ਬੈਠਾ. So A B ਨੂੰ ਬਾਹਰ ਬੁਲਾਉਂਦਾ. ਸੋ B ਆਪਣੀ ਵਾਈਫ ਨੂੰ ਕੀ ਕਹਿ ਕੇ ਜਾਂਦਾ ਵਾ, that ਮੈਨੂੰ A ਬਾਹਰ ਬੁਲਾ ਰਿਹਾ, ਸੋ ਆਈ ਐਮ ਗੋਇੰਗ ਟੂ A. ਠੀਕ ਹੈ ਜੀ? ਉਹ ਬਾਹਰ B ਕੋਲੇ ਜਾਂਦਾ, B ਬਾਹਰ A ਕੋਲੇ ਜਾਂਦਾ and A shoots him directly. ਤੇ ਕੀ ਹੋ ਗਿਆ? ਮਰਡਰ ਕਾਜ਼ ਹੋ ਗਿਆ. ਸੋ ਇੱਥੇ ਜਿਹੜੀ B ਦੀ ਸਟੇਟਮੈਂਟ ਆ to his wife that A is calling him outside the house, that statement will be a relevant fact, because those are the circumstances that led to the transaction of his death. So in any matter where the question will be the death of the particular person, and those facts which states the cause of death or circumstances that led to transaction of his death will be relevant facts. ठीक है जी. So it is very important topic. So if you want any case law or you want any kind of notes or you want any kind of other assistance, you can message me or you can just comment down below the video so that I can help you according to your needs and requirements. So as of now, it is very important topic. You must read BSA Act and along with your textbook, so that you can get to know the evidential value of the dying declaration, and along with that you can read important leading judgments. So for today we are keeping it light, so that we so you can understand the dying declaration concept very well. So, and after today's class we will be covering all other 7 conditions where again the hearsay evidence will be a relevant fact. So another announcement for you guys is that from today itself, so our team will be starting a new subject that will be a Bharatiya Nyaya Sanhita, which has replaced Indian Penal Code. So Dr. Amandeep Sharma will be helping you out in clearing your all doubts and queries in Bharatiya Nyaya Sanhita. She is very qualified professor and she is a gold medalist in BALB. So it will be very beneficial for you guys. So you must attend those classes also if you want any kind of assistance in Bharatiya Nyaya Sanhita. So from today itself, your Bharatiya Nyaya Sanhita lectures or classes will be beginning by Dr. Amandeep Sharma.